Hey guys, today we're going to talk about the third element of defamation, which is reference to the plaintiff. The defamatory words have to refer to the plaintiff, the person showing. In other words, you have to show that a third party would reasonably understand that the defamatory words refer to the plaintiff. The English case of Houghton and Jones held that the intention of the defendant to defame the plaintiff is not a requisite. So he can still sue the defendant for defamation, even if it was not the intention of the defendant to refer to the plaintiff, but it was the defendant's intention to refer to a fictitious character bearing the same name. In Houghton and Jones, the defendant was a newspaper which published an article about a certain Artemis Jones, who was in the article. It referred to Artemis Jones as a church warden who had an illicit affair with a woman, and then the real Artemis Jones sued the newspaper, and the court found that the newspaper did in fact refer to the plaintiff, who was also Artemis Jones. Similarly, in the English case of Newstead and London Express newspaper, the defendant newspaper wrote an article about a prisoner on trial for bigamy, and coincidentally, the plaintiff fit that description. He sued, and the court found in the plaintiff's favor. So, what do these two newspaper cases mean? It means that an innocent defendant bears the risk of coincidence, but he can rely on the offer of a man's defense if he can show that he innocently defamed the plaintiff and exercise all reasonable care in relation to publishing that article. Also, if an author of an article or the producer of a film states at the beginning that all characters are fictional and any resemblance to real events are purely coincidental, it will be taken to exclude reference to a plaintiff if there was any coincidence. Now, let's talk about group defamation, also known as class defamation, which is defamation to a class of people. The Singapore case of DHKW Marketing and Nature's Farms Private Limited dealt with this issue of group defamation. Nature's Farms sold pycnogenol, which was discovered by Professor Mescalier. Nature's Farm placed a newspaper advertisement stating that only pycnogenol manufactured in accordance with the professor's formulation was original. And in the newspaper advertisement, Nature's Farm also exhibited a letter from the professor saying that he was the inventor of pycnogenol and that he discovered that his trademark and formulation was fraudulently used. The High Court held that the statement, the newspaper advertisement, was defamatory because it imputed that people who sold pycnogenol other than Nature's Farm was selling it fraudulently. The Singapore High Court in Price Waterhouse Intrust and Wee Cho Keng held that an ordinary third party's knowledge of the particular circumstances and facts in which the publication was made would be relevant in determining whether reference was made to the plaintiff. Let me give you an example. Some of you may have come across comments on social media making reference to dishonorable son. Although there's no mention of the name dishonorable son, I think most of you know who it refers to. So under such circumstances, because the public's knowledge of the public comments on this person would make people naturally think of this person in question. So such reference would be referred to as innuendo. So to sum up, in determining whether the defamatory words referred to the victim, the crux is whether the victim can be identified by the words or pictures in the statement. So thanks for watching this video on references to the plaintiff.